Hello, it's the Catholic CEO, Henry Kutarna. Welcome to this Catholic Business Wisdom series. Topic today on P protection, intellectual property protect. What is this all about? Well, in summary, what it is the protection of all of the essential information and data and branding and items, processes, procedures that make your business unique. It's the things that you want to protect from your competition so that nobody steals or copies or does something inappropriate, illegal, or immoral with your business. It is also, intellectual property protection is really a protection against unfair usage, unfair advantages that people might take from stealing your intellectual property. Intellectual property is physical things, physical assets, physical goods, but it's also intangible things like your brand and like your products that include things like music or art or the written word. Intellectual property protection is a big thing. It's something that I would really want you to take special care and attention for. Even if you're doing a side gig or a small business or any kind of an operation that might even be hobby in nature. If you have a business, you're earning revenue from it, and you have a unique identity like corporate status, or even if it's a sole proprietorship, you will want to pay attention to protecting your intellectual property. What are some examples? Well, let's go into a couple of examples here. The obvious one that might come to your mind is patents. If you are producing a piece of electronics, a certain type of product, a certain mechanical process, you might be applying for a patent. This is an expensive procedure. It costs money because you have to select patent application for different countries or regions of the world. But a patent is a protection against copying and therefore the commercial rights and the sort of revenue advantages to your industrial process or your technology. A patent is an official designation that protects you, and it can be enforceable. So you can sue, you can control the use of your technology and your industrial processes through the use of a patent. A copyright is slightly different in that it applies to documents, literature, music, the spoken word. You can issue a copyright and you can register a copyright as well in various jurisdictions, different countries, different regions. The idea of a copyright is that when you produce something like music or art or the written word, documents, flyers, information, that include thoughts and concepts of the mind as applied to the written word or put down on paper in terms of, let's say, music or art, the copyright protects you from, again, the unfair usage from somebody else. A trademark is, again, slightly different. It's applied mostly to products or versions of your products or items that you sell that you want to, in a sense, label according to your company, its brand, and your unique products and services in the marketplace. So a trademark also can be registered in a different jurisdiction, and it can be used to protect your uniqueness and identify a product in the marketplace as belonging to you and as being manufactured and produced by you. It's not a guarantee against counterfeits or copies, but it is useful in that. Your industrial processes, I'll call them, are also part of your intellectual property, and they deserve to be protected. So what kind of processes am I thinking of? Well, I'm thinking here of documents that outline how your work is done, whether it's the simplest side gig or even a not-for-profit organization or a company. When you have a process and you write it down, that's part of your intellectual property. That's to be protected, and it's not to be given easily to your competition so that they can copy and therefore gain an advantage over you because of the intense work that's required to pull it together. Your contracts, your industrial processes, your recipes, think of it another way. Your formulas, the components that you use to put together your product, even the way you cut wood or saw wood or cut metal or fashion your products, even your services. These processes that you follow, let's say you're an advisor, you're a consultant, you might be an analyst, you might have templates, you might have diagnostics. The idea is that your processes, as written down or recorded in audio or video or any other digital format, are really to be protected. And so, you would want to protect your what I call industrial processes. Your technology itself, the actual components, if you make a black box, a little electronic product, you want to make sure that nobody can really easily reverse engineer it and copy it and sell it into the marketplace. And so everything we've talked about already, like trademarks, copyrights, patents, your industrial processes, they are all part of preserving and protecting your technology. That's why you will often see in the technological game, people will make sure that your black box can't be opened, or that it is disguised, or that it requires some sort of downloadable software from the cloud to initiate it or to keep it in use, in actual operation. Your contracts are part of your intellectual property that you would want to protect. Why? Well, because contracts contain the details not only of compensation and duties, but also they spell out the role that the person will play inside of your company. Assemble enough of those and you get an idea of the corporate structure, which may not always be public information. And so that's just an example. Contracts with suppliers may actually also reveal information to the wrong parties about what components go into making your product, where you get it, how long does it take to get, what is the pricing. All of these are advantageous for somebody to steal from you if they were so inclined. And so your contracts are something that you would want to protect. All of your formulas that go into what you do, if you have mathematical formulas that talk about dimensions of products or recipes and ingredients into liquids or food articles, or different composite products that go into making up your final product, what I might call recipes and formulas, these are all part of your intellectual property protection, and they must be guarded as well. There's a notion of prior art, which means that anything that you have done as a process or written down or saved in digital format is proof that you have been in the marketplace and you have had actual production time, and that you are an entrant and a participant in the marketplace. And you can usually mark the date when that started, and that can prove that you were in business earlier than somebody who, let's say, is a copycat or who steals your intellectual property from you and then uses it in competition with you in the marketplace. How you protect all of this intellectual property that we've talked about briefly today. Certainly you would want to store physical items in a safe location, that is a locked safe or a safe itself, or a locked facility. Sometimes the things to be protected are large enough that you need to have a safe, secure room or even a building. You will see in some of the metropolitan cities huge buildings that are clearly the storehouse for intellectual property, technology, process, machinery, equipment, software, that sort of thing. If you have hard drives in a small business or flash drives, you don't leave them lying around on the desktop because someone can quickly grab those. You make sure your computer files are securely password protected and otherwise protected so that nobody can just put in a flash drive and grab your files and run off with them. Physical security then, and also protection from stealing by the use of mobile devices like a phone, like a camera, like a flash drive, like a hard drive. It's important to also have what I call NDAs, non-disclosure agreements. Sometimes non-competes are in the same realm, but the confidentiality agreements are designed to protect you from unfair use or illegal use or theft of the intellectual property. An NDA is a protection. It's not a guarantee. None of this is a guarantee, but it all helps to show that you have conducted your affairs with due diligence and that you have been in the marketplace producing your service, your product, selling it with the right to own the branding, the trademarks, the copyrights, the patents, all of the contracts, all of the industrial processes, the recipes and the formulas, according to your unique combination of all these resources in order to sell into the marketplace. And so you would want to protect these either physically or in digital format, and you would want to guard against unfair use. You would certainly also want to produce or protect the buildings, your physical facilities, your complex, your yard, or if you're a small operation, the room or the place, the basement, the garage, the little shop. You'd want to protect that properly with cameras, security devices, card locks, fences, gates, motion detectors, sensors, all this type of thing. And so the concept of intellectual property protection is perhaps more than we think. It's broader, and sometimes we're too trusting. We leave information, we talk too freely, we speak about things, we give away our recipes and our details of our contracts and our information too freely, and it allows somebody then to steal the intellectual property that is our right. A couple of cautionary notes then. There are patent trolls out there. These are people that will search your patent and they will make a claim that your patent infringes on their patent, or they might get a patent on something that's very similar to your product, and they'll start manufacturing it and they'll come to you and claim that you're infringing on their patent. Sometimes the patent troll will engage you in the legal fight, which means you're going to spend money and time and resources that you don't want to spend on that as a way to protect your intellectual property. A patent troll is, somebody that I'm sure you've heard the stories about these, but you have to watch and be careful about them. There are many, I call them fake lawsuits, where people will decide that they're going to come after you because your logo, your brand resembles theirs, and sometimes it's for real and sometimes it's not. And even in the engagement thereof, where you're going to spend time and money, you will waste that time and money, and that's intended to take you off track. One of the other cautions then is speed to market. It's important that if you're going to have a secret process or a confidential process or a unique combination of electronics and software and so on, you need to move into the marketplace quickly and establish your presence in the marketplace to show that you were the initiator of that technology and that you weren't copying somebody else's. One of the other scams that's out there in certain countries is you'll order, let's say, 1,000 units of something, whatever it is, 1,000 black boxes of your little electronic device that you're making and selling into the marketplace. But the company will produce 1,100 units, and they'll sell the 100 units, figuratively speaking, out the back door of the factory while shipping you 1,000 of the units. This is a well-known scam. You need to do some research to understand which countries do this or which areas of the world might be subject to doing this. And so you would want to be careful about these. In general, then, in a summary way, intellectual property protection needs to be thought of a little bit more carefully. For you as a business owner, I would urge you to take steps right now to protect your physical property, including everything from your building and your tools and your equipment all the way down to the software and the papers, the contracts, the documents, the items on your computers, the items on your devices, your photos, your industrial process, the people who work with you and for you and the contractors. If they have a role to play in guarding the processes and the tools and the equipment and the intellectual property, you need to protect that with contracts, NDAs, confidentiality agreements, and so on. So there you go, a little summary of the intellectual property protection topic for your benefit. It's not guaranteed to be foolproof in any way, but it's definitely necessary for you to take proper precautions and steps to protect your intellectual property. So God bless you in your business enterprise. It's the Catholic CEO, Henry Kutarna. Thanks for listening, and we'll see you next time.